Kia ora koutou. I think I might make a start. We've got quite a few participants signed on already, so welcome everybody. My name is Sophie Mears. I'm a member of the ILANS committee, and it's my pleasure to welcome you all here to our webinar today on behalf of ILANS and the ADR Centre. Our topic today is ADR in the House, about leveraging alternative dispute resolution for effective legal management. So just before we get started, a little bit about our organisations. So ILANS is In-House Lawyers Association of New Zealand. We're a proud section of the Law Society, and we're committed to supporting, connecting and leading the in-house community across Aotearoa. With me today, I've got Gracie and Catherine from the Alternative Dispute Resolution Centre, and they are the leading independent and nationwide provider of commercial dispute resolution and conflict management services in New Zealand. So on behalf of the ILANS committee, we'd like to thank the ADR Centre for both your sponsorship in the recent ILANS conference in Blenheim, and also for presenting to us today. So a little bit of housekeeping for the webinar today. Gracie and Catherine will present for approximately 45 minutes, and then we've allowed 10 to 15 minutes for questions. So if you have any questions, please make sure you put them in the question and answer box on Zoom. And so thank you. I'm delighted here to welcome our presenters, Catherine Green and Gracie Campbell. So Catherine is a director at the ADR Centre. She's an expert in private dispute resolution processes, and her qualifications include an LLM in international law, an MBA and a BA in employment relations and organisational studies. And Gracie Campbell is a senior lawyer in the dispute resolution, investigations and regulatory team at the Bank of New Zealand, and she manages significant litigation for the bank and provides legal support for its regulatory and compliance functions. So welcome both of you, and so over to you.
Thanks, Sophie. We'll just hold on a second, bear with me for a second while we get control of the screen, which hopefully we should have now. Right, thank you so much for having us today. We were absolutely delighted to see the level of interest in this topic. We could literally go on for hours, but we won't. So we've tried to produce an outline that's fairly general, but hopefully gives you a little bit of practical knowledge as well. We know that we're going to have questions and answers at the end, but also if we can't get through something today that you really want to know about, feel free to reach out to us at any time. Today, we're going to run through, try and give you a bit more of an understanding of the importance of private dispute resolution, particularly in the context of in-house legal practice. I'm going to talk a little bit about the various dispute resolution options that are available to you. And then, as I said, we're going to get into that practical knowledge. So how can you leverage dispute resolution for effective legal management? How do you go about selecting the most appropriate dispute resolution method? I'm going to talk a little bit about model clauses, because typically that's actually when it's determined. And then we're going to look at a few real life examples to really try and put this into practice. So with that said, I'm going to hand over to Gracie for the first section. If I can make the slides move for her. There you go.
Yay, technology. Yeah, so thanks, Catherine. I'm going to start by talking about why private dispute resolution is important for in-house lawyers. I'm going to assume that most people in the audience are not full-time dispute resolution in-house lawyers like myself. Not many businesses have dedicated resources in that way. And that's because disputes aren't typically part of your BAU as any business. It's unless you're a law firm, then that's just not really why your company exists. So it is something that is often taking time away from your actual usual activities and the strategy that you're trying to achieve. So, and even within businesses that do have an in-house legal function, again, they're usually geared towards making stuff happen rather than dealing with disputes. And so all businesses have a finite amount of resources, and they're going to be using those resources as much as possible to align with their 5-year strategic plan or whatever goals they're trying to achieve. So coming up with options of how to effectively manage so that you're not taking time and cost away from your strategically aligned activities is where private dispute resolution really comes into play. And it's not to say that it's the solution to all things. There's sometimes a strategic reason why you might want a public court determination or a transparent public process. but it's important to understand that there's actually an important role to be played by alternative dispute resolution, which can be confidential, can be quicker, can be cheaper. And really the biggest thing that I focus on in my practice is around managing internal and external costs, because it's easy to think about just lawyers' fees when you're thinking about disputes, but actually managing a dispute in-house is an incredibly time-intensive process, especially for a piece of court litigation. It's not just my time, it's staff member across the business who are really the people that would have to give evidence, know where the documents are, have to work with our external lawyers to explain what's happened and what the position is. So we have a significant piece of litigation at the moment that literally requires a dedicated person within the business to meet with us every week. And that's an hour of his time every week that he could be using towards actually achieving business goals. So it's not just about looking at the external costs. And so when we're having discussions with our stakeholders about how to manage a potential dispute, we talk to them about, don't forget the opportunity cost. You might think that this feels like an important issue right now, but will you still feel like it's an important issue in 2 to 3 years' time, and you've already, had a team of people that have been taken away from their day jobs to do this? So those are the types of conversations that I have all the time. And obviously, just depending on the size of your corporate, you may or may not have, a lawyer like me that has that in-house disputes experience. But ultimately, we are a support function and a cost center. We don't generate money for the overall enterprise. So making sure we're doing things efficiently is really important, and adding value where we can. So I think that sets the scene for thinking about the different types of disputes that a general corporate might find itself in. I came up with 3 buckets today. So customer-facing disputes. So most businesses are probably interacting with customers in some way or another. And so disputes might arise in that context. Your contracting partners or insurers or similar, so sort of your procurement area disputes. And then you might have regulator issues or issues with government. And that last bucket is not really applicable today. We're just going to focus on the top 2, because generally, unless there's a legislative requirement, that'll be a court action. So I think in the examples that we're going to talk about, we're going to be thinking about those customer and those contracting partner type disputes. So let's go over to Catherine.
Thanks, Gracie. So in front of you, hopefully you've now got a slide that has all the different process options for dispute resolution. I'm not going to be able to go through all of it in great detail because I've got about 5 minutes to work my way through this. And I also appreciate that we'll have people on this webinar who have varying degrees of experience in dealing with any of these processes. So bear with me if I go over something that you already know. But hopefully by the end of this 5 minutes, you'll have a bit of an idea of all the different options that are actually available, and possibly it's more than you might have thought. I'm going to run through this quickly, starting on the left-hand side where we've got the more informal of the processes. And I'm sure the first is very, very familiar to everyone, but obviously negotiation, it's typically where parties will start having those informal discussions. It's very adaptable. It can fit your business to business or your business to consumer context. In terms of an outcome, it may result in an agreement, and that often will become contractually binding, but it really depends on the situation. I think the key point is that negotiation, because it's so flexible, it's so informal, it offers a great deal of control to the parties involved. And as I said, it's often the first step in resolving disputes. Moving to mediation, which comes second, that's also a relatively informal process. It is consensual. You can't make someone mediate. But in this context, it's essentially a facilitated negotiation process. So a mediator will come in and help the parties to have that discussion and help to explore the issues, generate potential solutions, reality test, and hopefully come out the other end with an agreement. And again, if it does, typically it will be contractually binding. Often mediation doesn't necessarily result in an agreement, and that's not necessarily a bad thing. It might be simply that you've managed to narrow down the issues, or you've identified that you need more information. There's all sorts of outcomes that you can get in a mediation. Early neutral evaluation is the next one on the list, and this one may well be unfamiliar to a few people. This is not used very often, but it's where you have an independent evaluator, and typically this will be someone who is, say, an ex-judge or someone who is of sufficient standing that the parties will invite them in to assess the case, assess the facts, the legal merits, and offer a non-binding evaluation of the merits of that case. It's particularly useful for complex disputes where you've got large-scale litigation or large-scale arbitration looming. It's a good way to kind of reality check for the parties and to get them around the negotiating table. Expert determination is there. That one might be a little bit more familiar. That's where a dispute's referred to an independent expert with relevant expertise. The outcome can actually be binding or non-binding. It's completely up to the parties to agree that, but be wary of that. You need to make sure that you know what you're getting when you sign up for expert determination. It's particularly helpful for technical disputes where the expert's knowledge can provide, a clear path forward for the parties. Dispute review board in there, that's typically only comes up in large scale construction projects, although it could have relevance to any kind of project work. It's quite flexible and it's project based. So it encourages resolution early. You have someone that's involved in the contract from day one. So they're very familiar with the parties, very familiar with the issues, and they're able to step in either to facilitate or to make a determinative decision as issues arise throughout the course of that contract. So I guess one of the key things for that is that it can help that project momentum. You don't get stuck because there's someone that's already up to speed who can help when an issue arises. Adjudication comes in next. There's two forms of adjudication. It's more familiar in the construction context where we have statutory adjudication under the Construction Contracts Act, but there's also contractual options available. We offer it through NZDRC domestically and NZIAC internationally. But that's really is a fast track process. You get a decision at the end of the day, which is binding in the interim. So that means that if the parties are really, or one or other of them is really unhappy with it, they can have another go in a different forum. But typically what we've seen is that they actually just go with the decision of the adjudicator and move on. It's a very commercial decision. ArbMed is in there. I'm conscious I'm running out of time. Combination of arbitration and mediation, hybrid process, get the information on the table, hopefully have a good mediation that's informed by having that information there. If there's a settlement, then that can be recorded in an arbitration award on agreed terms. And if not, it can go straight into arbitration. So it's a streamlined process in that respect. Arbitration at the end there, that's the really formal one. It's the one that's closest to litigation, but it doesn't have to look like litigation. And in fact, it shouldn't if you're going to have a good arbitration process. In this case, you'll have an independent person or a tribunal of typically of 3. They will be appointed to decide the matter in much the same way as a judge might. It doesn't have to have a hearing. It could be on the documents. There's lots of flexibility in terms of the process. But that award is enforceable in the courts, and it's more readily enforceable cross-border than any judgment in the courts. So particularly helpful in that cross-border scenario. Won't go into litigation. Everyone knows what that is, but that's obviously the next one there. So I think just to say that each of these methods it has its unique features and suitability, and it's going to depend on the nature of the dispute as to which is going to be the best one out there. So I think on that, I'm going to quickly hand back to Gracie, and I'll come back to which option is best shortly.
Yeah, lovely. No, that's really helpful to some of those I wasn't familiar with. And you're not expected to be an expert in every single one of them as the in-house lawyer that's providing that support, but having the flags in your mind of, oh, I know that there's some options here, I better go and have a look at them is really helpful. So I think it would be helpful just to actually start this slide with explaining what I'm meaning when I'm talking about legal management in this context. when you're actually specifically in that disputes world, because my function is very different to the external disputes lawyers that I work with. I'm very much the facilitative conduit between the two of them. I sort of see it because I have the experience of what's going on in the business and can help explain their position, and I also understand what the lawyers are doing and trying to translate it so that the business understands the decisions that are being made and the options that are on the table. So we are not obviously instructing in the sense of making the decisions. It's about facilitating the business to make the decisions and what instructions they want to give. But it's making sure that both sides of the fence are well informed and speaking the same language is really the overarching point. But to dig into that in a little bit more detail, I'm sure a lot of you in your other types of in-house legal work that you're doing understand a lot about working with the business to understand their drivers. Why are they making certain decisions, or what are they trying to achieve? What's most important here? And that feeds back into that smorgasbord of dispute resolution options that Catherine just talked about. It might be that this is extremely confidential, and for whatever reason, the business finds this is a really sensitive topic and absolutely does not want this to be public. So, okay, well, litigation is off the table for us because we just simply do not want this to be public. So we're going to be looking at this end of the spectrum. And it might also be, in a business like the bank, where trust with your customers is really important, and knowing that customers will want opportunities to just be heard. Having a mediation process is really helpful, and that's why we have things like the farm debt mediation scheme that has been adopted. It's creating a forum for those customers to be heard and for creative solutions to be reached, rather than just the bank writing a check every time or having some kind of aggressive interchange. So it's putting those two things together, and so really getting to the heart of what the business is looking for, and not just thinking about the legal merits, because that's what your external lawyers are probably engaged to do. The next piece is about being able to advise on the options. So the earlier that you can start thinking about what the potential processes could look like, the better. I have so many conversations about when people come to me with a particular problem, and you think, well, is this something that you're prepared to fight to the death over for the next 8 years, or is this something that we can solve by way of these alternative options? Because if you don't know that there is actually a private, quick, cost-effective way to solve it, then the business just won't do it a lot of the time. So it's a way to make sure that you are actually pursuing the things that you should be pursuing, or that's for the benefit of the business to be pursuing. And having that understanding from day one means that you can set yourself up for success going forward. And like Catherine mentioned, you can make sure that in your contracts, you're having the right model clauses so that those options are available to you. So even if you're not advising on disputes all the time, knowing that these options exist is going to help with your contract drafting going forward, so that you know what you've got proportionate dispute resolution options available to you if anything does come up. Providing instructions. I think I could probably talk a little bit more about some examples of how we have been, in my team, adding a bit more value than just simply passing on, this is what the business says. We have a lot of pretty sophisticated people in the bank that, particularly in our enforcement teams, in terms of they handle a lot of dispute related work all the time. But we've had something recently become a lot more complicated than they're used to. And so you're having to explain to them, why is this happening? Why is the judge doing this? Or why is the lawyers suggesting that we do X, Y, and Z? What does this actually mean for me strategically? And being able to explain it to them in a way that is meaningful to their day-to-day job, so that they don't just keep saying, oh yeah, sure, whatever the lawyers say, is really important. And equally explaining to them, why is it that the lawyers need that information? Why does it need to be in that format? Why do they need it now? Why are these deadlines important? Is definitely a big part of the job, and it actually does make things efficient and cost effective. So that's definitely a really important part of what we're doing. And I had an interesting example recently where lawyers that were acting for us asked me to find someone in the bank who could provide an affidavit about our AML compliance procedures. And I had to explain that engages about 4 different teams across the bank. It's a bit unrealistic for me to find one singular person that covers all of those things. So being that that translator is really important. And the final point, we're going to talk about costs a lot in this presentation, I think, because if you haven't done disputes before, then you don't necessarily have a concept of what the costs are likely to be, and also how much stuff should cost. So we, in my team, play an important role in sense checking all of our estimates that we get, making sure that the lawyers are sticking to those estimates and updating them, but equally socializing within the business. You're going down this path. This is a kind of budget that you can expect. And that's where having private dispute resolution options can be really useful as well, because you can actually have a bit more certainty and control over what those are likely to be, because you're dictating the process. You are opting into certain stages. Whereas things in court can be a little bit out of your hands and a little bit more freewheeling in terms of not what the judge may or may want to do. So being able to go to the business and say, hey, we've got this problem. It is a problem that's maybe worth X amount of dollars to us. We can present a private dispute resolution process that we can go through that is either already in our contract, or that we can propose to the other party to the dispute, where we're actually going to be able to deal with this proportionately instead of going to court and spending what it's worth just to get to the answer. So yeah, we're a sense check on both sides of the fence, I think. So we're going to talk about practical steps for using ADR. I think that it sort of dovetails into what I was talking about before, about making sure you understand the processes, and you don't need to be an expert in any of them, but absolutely talking to Catherine and her team and utilising the resources that they have online. I've downloaded a few brochures and shared them around my colleagues in our procurement team to make them aware of different options that they could be considering for our contracts going forward, to make sure they're including them. So just having ideas of what they are, having a little flag in the back of your mind, being like, oh, okay, if I want to have a supported negotiation, or these negotiations aren't going very well, why don't I check in with NZDRC and see what other options are available? Did you have anything you wanted to add to that first bit?
I thought I should just clarify one thing, because it might be a bit confusing. Just for anyone who isn't that familiar with our organisation, the ADR Centre actually has 5 different businesses that sit within it, and one of them is NZDRC. That's just the New Zealand Dispute Resolution Centre, so that's domestic commercial cases, which is why we've tended to refer to it in this presentation. But if you come to us, you can talk to us about any case, whether it's international, domestic or construction. We'll point you in the right direction. Don't worry about that. Yeah. And it is important to understand those process options and to understand them early. So again, I just say reach out at any stage, ideally before this even comes up as an immediate issue, just to upskill you and your teams so you know what's out there. Yeah.
And I think understanding the outcomes for those processes is the important piece. And I think, as Catherine touched on in her earlier slide, everybody knows a court results in a judgment. But understanding that a mediation, if you want it to, can result in a public joint statement between you about an issue. And I could certainly see scenarios where that would work in a banking context where we've got a dispute with a customer or a group of customers where there's often media interest, and from both sides, it's important that the world at large knows what happened rather than it was just something done behind closed doors. So certainly familiar with that being something that I can, and I have seen it used in other situations, which have been really useful. And understanding that certain things are not final is very important as well. So just working through all of that when you're talking to the business is really useful.
I actually think your example is really quite useful, Gracie, because I think there's a perception that public litigation is public and private dispute resolution is private, but it actually doesn't have to be. Private dispute resolution is just really flexible. And typically it's what the parties want to happen. So yeah, by all means, you can certainly have public statements, and that can often be something that's quite useful.
Absolutely. The next step is, so you've had to think about what process you want to engage. Often another barrier as well, who on earth am I going to use as my mediator or arbitrator, or I've had this person proposed, and if you're not operating in the disputes world and you don't have that network, then how do I know who to use or where to go? But there are referral bodies, including NZDRC, thank goodness.
I was going to say, again, just reach out. I was at a conference recently and someone made the comment that there's not enough commercial mediators in New Zealand. There are so many, so many. But people just don't know who they are, and they tend to go to, and I did this when I was a litigator as well. You tend to go to your colleague next door and say, who have you used before? How were they? You're not really expanding your circle. So yeah, do reach out at any stage. And there are loads of very, very good ADR professionals covering all sorts of different process options out there. For diversity's sake in particular, I always like to put a plug in for this too. We really want to see more diversity in terms of the professionals that are appointed. But unfortunately, if you just go back to the ones that have been appointed previously, it's not really helping diversity either.
Absolutely. I was just thinking that same thing. And it's when speaking at that same conference, and really encouraging mediators and arbitrators to be really easily locatable. When I Google you, make sure that you are putting your hand up for certain types of work, making sure it's clear what your expertise is and your specialties. So I can certainly, I'm sure, I know that there's definitely sort of equitable briefing directories and things like that out there. So tons of resources so that you can feel confident about who you're using, because it's certainly, again, a discussion that I have a lot with the business on our disputes is, are we comfortable with who's going to be making these decisions? That's something that's always front of mind. So yeah, that's knowing that I can call Catherine is very helpful, and I have done so. And yeah, that we've got that last box there that I think we've already touched on, is really thinking about what are the outcomes that you're looking for. And again, that is where you as the in-house lawyer add so much value, because you can be across both sides of the spectrum here, is understanding, well, what is palatable for your stakeholders within the business, and talking to your lawyers about, well, how do we achieve that? These are things that are simply off the table, or these are things that we are keen on. So I think we can move on to...
Then we're going back slightly, but I did promise it would cover off. I can't really answer this question, but I'm going to do my best to give you some pointers. Which option is best? It just really depends. But the first point is actually the key point, and it's actually the one that you as in-house counsel have more control over than you realize. So for a lot of these processes, in fact, pretty much all of them except for statutory adjudication, you have to agree to engage in the process. So the first question is going to be, do you already have agreement, or do you need agreement? Because that may well determine what path you can go down. You want to make sure, assuming that you can either have some agreement or you can get agreement, you want to ensure that you're getting the most proportionate response in terms of both time and cost. Gracie gave a very good explanation about the cost to the business is not just the cost of the lawyer's fees or the cost of the process itself. there is this very significant business time cost involved in tying up internal resources dealing with a dispute. We've talked about outcomes quite a bit, so I won't say anything more on that other than just bear in mind you need to know what outcome you're going to get from the process you select. And that kind of goes to the next point. What's the likely result? What are the possible results? And that just comes down to a risk assessment that needs to be undertaken. I do have a couple of points there because they're two that come up fairly regularly. A lot of people say, we don't want to arbitrate or adjudicate because it's too adversarial. It doesn't actually have to be. And in fact, I've got an arbitration myself right now, which is, it's great because both the lawyers, the parties just can't agree on one particular issue. There's literally one question I have to answer. So they've referred it out to me to make that decision. And it's not at all adversarial. They're just putting forward their arguments. I'm going to make the decision and then they can move on. You can also mediate and negotiate at any time. I'm going to talk about that just quickly when I look at the model clauses. Just bear in mind, you don't necessarily have to agree to do that up front. Often if you've agreed to arbitrate, or if you don't have any agreement and you're actually facing litigation, that's quite a big, that's going to encourage people potentially to get around that negotiation or mediation table. So just bear in mind those points when you're thinking about what option might be best for your situation. Unfortunately, it really typically comes back to the first one, and that's model clauses. We do actually have guides on model clauses. So they're one of the resources that Gracie was referring to just before. By all means, download them from the website or reach out and we can send them through to you. You've got to get this right. If you don't get it right at the outset, you either aren't going to be able to access these processes down the track when a dispute does arise, or you're going to end up in a process that is just not fit for purpose. You could spend a lot of time arguing about things like who is going to be appointed as the arbitrator or mediator or whatever the process is, how that process is going to work. That is all going to cost a lot of time and money. I think the reality is that when anyone is entering into a contract, they're not really thinking necessarily about what's going to happen if things go wrong. Sometimes we hear from people as well that they don't want to even discuss it because it's perceived as being negative and kind of thinking, well, putting it out there that something is going to go wrong. You just need to get past that. It's really, really important that you get this right from the outset. I've also got in there avoid multi-tiered waterfall clauses. These are really popular. They're terrible. I've seen so many arguments come up because of them. As I said, you can agree to negotiate and mediate at any stage. And in fact, forcing someone into a negotiation or mediation at a time that's just not really a good time for them to engage in that way could actually put them off doing it later down the track when it is right for them to engage. They might have more information, things have moved on. So I always say you're much better off just putting an arbitration clause in, or an adjudication and arbitration. That's the only multi-tier I'd ever suggest, because you can just negotiate or mediate later. And if you've already got that arbitration kind of on foot, that's a really, really good motivating factor to get people around the table. Make it proportionate. This goes particularly for arbitration. Arbitration can start looking like litigation. It can start taking a huge amount of time. It can start costing a huge amount of money. What we have done, certainly in our rules, if the agreement is to arbitrate under our institutional rules, is that depending on the value of the dispute, you automatically end up in one or other of the processes that is designed to be proportionate to the value. So it can be a little bit rough and ready in terms of, maybe there's a small value dispute that's actually really more important and we might want a bigger arbitration process. The reality is you want to start with the most proportionate process. You can always agree to do something else later if you need to or want to, but if you don't have that agreement up front, typically one party or the other will just simply not agree to whatever it is. They may not even engage. So you could spend a huge amount of time and money arbitrating something that's actually relatively modest. Those rules also, I should say, provide for a stay to mediate. I mean, I think that probably goes without saying for most arbitrations anyway, that I don't know any arbitrator that wouldn't agree to a stay if there was a mediation on foot and the parties requested it. So that's the model clauses.
I think before you move on, Catherine, I would just reiterate your point about getting that clause right, because I've been back at the bank probably about 10 months, and the number of times that I have had people come to me about contractor disputes, and they've got these really complicated dispute resolution clauses of, oh, well, this representative needs to spend 10 days talking to this representative. And I was like, did anyone look at this? Because none of these representatives work for either of us anymore. And we've ended up in these other, you end up having a side dispute about whether the dispute process has been followed instead of worrying about actually getting it done. And so yeah, I've had it repeatedly in the last few, just in this year. So it's something definitely, when, as many of you are probably the contract drafters or reviewers at your organization. So keeping a close eye on those, because the people that are doing this as their day-to-day job probably aren't referring back to that. They're actually just having a commercial conversation, and then it's, oh, well, does that count as part of this process or not? So yeah, I just that was front of mind at the moment, so I wanted to reiterate that one.
Yeah, definitely. Right. I think we're getting on to some real life examples for our final section.
Sure. And obviously we can't go too much into detail with a lot of these things because they are confidential, but can just talk at a high level of supporting the business with a number of mediations with customers. It is really effective from my perspective. And being able to do it at any stage is exactly right from what Catherine was saying. I've seen it happen quite late in a dispute process, simply because the customer wasn't ready to sort of have that conversation until we got really to the stage with all the issues have been sort of fully there, and they felt like they'd had discovery and they got all the documents and things. And so we're able to do it at quite a late stage, but also for a couple we have on that we're looking at the moment, it's really how do we get that early stage mediation engagement and driving towards that, because we can just see it often where it involves not just the bank, where there's multi-parties as well. It's really useful to be saying, okay, well, how can we coordinate this towards a mediation rather than this getting unwieldy? So it's certainly something that we've got a close eye on all the time. And the mediator plays a really important role in making sure the customer feels like it's less of a David and Goliath situation as well, especially when you're working for a large corporate, that forum can be really useful. And a lot of the time, because you can, if you're in a large business, you can sort of feel a bit or appear a bit faceless to the customer. So they really appreciate that opportunity to have somebody from the bank in the room. And it can also be something that doesn't necessarily need to be over lawyered. It doesn't necessarily mean that, I have to go along. Certainly with our farm debt mediations, it's not something that I have to go along to, because we have really sophisticated business people that work in that space, and they go because these processes are a lot more user-friendly, and you have a facilitator in the room as well, so everybody's interests are being looked after. So that's probably that bucket. And then multi-party mediations is also the other piece. Touched on it a little bit there with the customer ones, but also for the more partner, contractor, insurer level, that's definitely a big one where we're always, how do we get this not to a court hearing? How do we get this into a room? Because there's just too many moving pieces. Just thinking about the collective cost of everybody writing a memorandum with each lawyer working on it, and if there's 4 or 5 parties, you're just, for the sake of society, this needs to not be taking up so much time. And so most lawyers who are advising their clients in those situations, I think, understand that having that opportunity at the right time to have a forum where everybody can just sort of, it's also brings a deadline to a decision-making process, I think, as well. I think for the internal business people, until you give them a reason to, draw a line in the sand or make a decision or make a concession, they're not going to. So sort of having a date, having a mediation can be, you can sort of set that date whenever rather than waiting for a court to set a date. So yeah, that's definitely, I'm always advocating for that, that's for sure.
Excellent. So I thought I would just select, I mean, there's so many different options, but I thought I would select two that really focus on kind of business continuity and efficiency, given that they're obviously two key areas of concern for anyone working in-house. The first one is and this is actually a really good example of the flexibility of process. So this is a very specialist mediation process that was undertaken. I can only give you brief details, obviously, in the construction sector. So it was where a significant conflict had arisen between the developer and the head contractor. The issues centered around things like project delays, quality of work, additional costs. Some of these cases can, if anyone's online that works in the construction sector, you know how complicated these particular disputes can get. And these disputes can often lead to the risk of project failure and obviously potential legal disputes arising out of them. So this is a classic case of where you really want to get around a table and get something resolved as quickly as possible to be able to get on with the project. So what happened in this case is that there was a referral to a specialist construction mediator. That mediator was provided with a significant amount of documentation in advance of the mediation. I'm not talking about a mediation process where you just turn up on the day and you facilitate a conversation. This individual came very, very prepared to engage with the parties on quite a technical level. And this kind of highlights another point that I often talk about is it's quite important, if you can, to have specialist mediators in the room. You're just going to get more bang for your buck if they already know what you're talking about. Anyway, so they went into this mediation, typical process, took place until the parties asked the mediator if perhaps they might like to just tell them what they thought the answer was. Now, if you speak to most classically trained mediators, they will shy away from that. There's no way that they would do it. This process essentially moved from a mediation to an early neutral evaluation within the mediation context. Because the mediator was a specialist, because they'd done that preparation and the parties were agreeable to this, it's the parties' process. They were able to do it and they were able to get that resolution on the day. So I think it's a really good example of those few things, having a specialist in there. Don't just turn up to a mediation ill prepared. Most of the work's actually done well in advance. And just thinking about it is the parties' process. Like, what are we trying to achieve? We don't have to stick to script if the parties are flexible and wanting to move in a particular direction. Having the right person in the room can actually enable that. So I thought that was quite an interesting case. It's not something that really happens very often, but it just is a good example of the flexibility. The second one, the last one, because I know we're out of time and I'm probably going to get kicked off in about 1 minute by Sophie, is just to think internally as well. We quite often work more broadly, not just in delivering a specific process for a specific dispute that might otherwise end up in litigation. We also get involved in things like conflict management and employment investigations. And this is a really important area just to really get in quickly. Early intervention is absolutely essential in this case before things get too far down the track. In this particular case that I'm thinking of, we had a public sector body who had some conflict in the workplace. It wasn't very clear what was happening. So we were able to put an investigator in. They were able to go and speak to the relevant people completely independently. So stepping away from it, this is where it can be quite useful, not necessarily to do a full-blown investigation with formal terms of reference, but just to get someone in early to have these conversations. And then they can make recommendations from there, which can look like all sorts of things. It could be actually that a mediation is important because we've identified what the issues are and who the relevant people are. It can also lead to more training, follow-up. It's incredibly flexible, but it's really important to get in early and try and sort out exactly what's going on and to give people a voice. So there's a huge amount of flexibility in terms of the work that we do. And hopefully that gives you a few examples. We could give many, many more, but it is 1:15 on the dot, Sophie. So I'll hand back to you.
Perfect timing. Thank you very much, Kirsty and Catherine. So we've got some questions here to ask. So the first one I'll ask, and it's related to what you were just talking about, getting in there early, is around the initial costs associated with engaging with the DIC. What does those initial costs and the initial process look like?
The initial cost, I mean, it really depends again. It's very hard to give a definitive answer, but what I can tell you, the first step is actually 100% free. Just ring one of our case managers or registry staff and they will speak to you. There's no cost for having that conversation. That's a large part of what they do, is to talk parties through, and their lawyers, internal and external, through what the different options are and what the likely costs might look like. So that's just a really good resource. That's where I would be starting. It's going to depend on the particular case. And often people come to us as well and they'll say, we want arbitration. And actually they walk out the door wanting mediation. So just have the conversation.
And you do actually have a few figures on your website, I think, Catherine, that I've seen before that I've used to share around for some of your like low value dispute schemes and things like that. So there is a few rates on there, I think.
Yeah, so there are specific schemes, low value arbitration and adjudication in particular, where we can do it on a fixed fee basis. So we're trying to provide that cost certainty, particularly where it is of a lower value. There's no point in pursuing something if it's just going to cost more than than what you're going to get at the other end of the day. So yeah, those options are there.
Awesome, that's really useful. And we've got a couple of questions here about model clauses. So I know you touched on that in the slide deck a little bit. You gave the link there to the model clauses on the website, which we will be making the slides available to attendees after the session. So that link will be available there. But could you talk a little bit a bit more about the model clauses, and in particular around requirements for appointment of mediators? So we've got a question here around some contracts, including a clause that says that it's an NZLS appointed mediator. Are there model clauses around that?
Yeah, so you can definitely have in your whatever process you want, just make sure you know who's going to make the appointment if the parties don't agree. I think there's too often I see them in mediation, arbitration, the classic ones, and like, if the dispute arises, we'll go to arbitration. Okay, so where are you going to get arbitrated? What is the arbitration process going to look like? It's more complicated for arbitration, but it's the same for mediation. So then if you're assuming you can't agree, you need to entrust that decision to someone else, whether it's NZDIC or the Law Society or Ammons or whoever it might be. You want to know how they're making those appointments. So I can talk to how we make our appointments, and because we don't just make an appointment and say, off you go, we work with our people. We peer review every single decision that goes out of these offices. We actually have a very good idea what our people are capable of. And so we can provide, hand on heart, I think that we are probably the only organisation in the country that can sit here and say, we know who we're appointing and we have full confidence that if we're appointing someone to a case, they are capable of doing it. They're also getting mentoring and support from our case management team and our internal knowledge management team. To put this in context, our team here is just over 50 people. So we've got a large degree of support sitting around them. They're not just operating solo. I can't speak to the appointment processes of anyone else, and I certainly don't. I take appointments from them as well, from a lot of different organisations across the country, and they fulfil a really useful function for people. So I'm not saying don't use them. I'm just saying that's what I think sets us apart in terms of how we make our appointments. We actually genuinely see the work of these people. So just bear that in mind. Also, if you're referring to someone to make an appointment, I mean, I still see a mediation to be appointed by leader. Leader doesn't exist anymore.
Yeah.
So you've got to be really careful about that. That leader is now a resolution institute, and it has been for quite a long time now, but I still see those clauses coming through. A few years ago, the chartered accountants actually went out to their membership and said, please stop putting our name in any contracts. We don't want to do this anymore. So just be wary of that. Whoever you are putting in there, make sure that they're willing to fulfill that function and are able to fulfill that function.
So a similar but well, a related question around the Independent Complaint Review Authority. So I assuming referring to the one in-house there that you have. So it's a private company as opposed to statutorily appointed. Yeah.
It is. We do deliver a couple of government contracts through it in providing review services for ACC and fire and emergency in particular, but yeah, it's private.
Excellent. We've got a question here from an attendee that usually does international contracts, so they're unlikely to get New Zealand law or New Zealand-based dispute processes. So does your organisation provide guidance on the UK and US dispute processes at all?
In terms of, I'm not sure exactly what the question was there. I mean, we do have an international presence with the New Zealand International Arbitration Centre. We can provide guidance in terms of those processes. I'm not sure if the person was specifically referring to a different centre, or I mean, the international arbitration operates very much the same across the board. It is the primary choice for dispute resolution internationally, and that is largely due to the fact you can enforce it readily.
Excellent. Yeah, because I think they're talking about the jurisdiction, the relevant law that applies to the.
Oh, right. Yeah. So when you do look at the model clause, if you are doing an international contract, please do look at NZIAC, not NZDRC, because it does have in there those specific requirements. You need to be. There is a default under the rules, but you do need to be thinking about that in terms of governing law and seat of arbitration as well.
And I think it's a good plug for New Zealand in general if you are doing international contracts, there's no reason why you can't be using New Zealand as your seat of arbitration. Certainly in my former life, we were doing a bit of work around this because there's actually a huge amount of lawyers in New Zealand that are international arbitration specialists because they've gone overseas, and that's quite commonly the practice area that you can do at a high level if you do go over to London or the US, and then they bring that expertise back, and they're a lot more cost effective here because the overheads are lower and all of the rest of it. So, and it's actually quite a good time zone for a lot of different countries. So just a plug for considering using New Zealand as your forum of choice.
Excellent. We've got a question here about many businesses who think that litigation is the bee's knees. So presumably they're talking about their governing body or their executive team. So what selling points do you think our in-house lawyers can use to convince the business to first try ADR? Obviously, we've covered it off a bit, but give us the highlights.
Instead of going to court, yes. I think I imagine the people that think it's the bee's knees are not the ones carrying out the discovery process the organisation. I would say it's really about exploring that piece of the cost benefit analysis for your people, the people that are working within the business and who are actually going to have to do the document collation and potentially appear as witnesses in a trial. Is that really what you want to put your staff through? Is that what they feel like they signed on for as part of their job? Because that is legitimately comes up relatively frequently as the bank being a source of information and data. People like to ask us to come and give evidence in court about a whole bunch of things. And it's not fun for staff members to sort of have those types of requests. So I think that's what I would focus on is one, looking at the what does that mean for your people in terms of having to go through that process, and how do they fully understand the timeline that they are committing to as well? Is this something that they're going to feel is the bee's knees in 6 years' time? And having a realistic grasp of that. And then, of course, replay this presentation for them about all of the wonderful features of all the good things about using ADR. There's obviously loads of benefits that we've talked about, but yeah, in terms of the more stick, I would be saying the time and cost is definitely for, when you're an unwilling participant in litigation, it is not fun.
Also, just another one is the confidentiality. I mean, do they really want all their sensitive commercial information available to their competitors?
True.
Very good point. Also, a question of mine related to that is managing the level of reporting and instructions that you seek from management and governance throughout a dispute process. Do you have any tips on how to avoid over-reporting? So, for example, obviously the managers and governors do not care about procedural matters, so do you have any tips about making sure that you're reporting to them at the key parts of the process?
In terms of making sure that they're aware of what's going on and making decisions and things. Yeah. I think you probably have your tiers of people in terms of what's the level of detail that they need to know. I think the key point is thinking about, has something happened which has impacted on your client, being the internal client's position? So has a turning point, even if it's just some new piece of information has come to light that has actually changed how they might make a decision. So I think if something's come up that I think actually the last discussion we had, things looked different and I want to make sure that you are still on board with the process that we're going down. I think that's probably how I think about it, rather than is it just a boring procedural update? It's that they might not be interested in. Actually, I've had this, really terrible letters come through and now you need to know about it, is maybe more important than an actual court appearance, which nothing happened and is, administrative or whatever. So that's probably the litmus test that I apply.
Excellent. We've got another question here. So about whether businesses can directly instruct barristers for ADR, but presumably that's something that the ADR can help facilitate.
Barristers, can businesses directly? So it depends. You can,
yes. As the practitioner, yes.
Yeah. So some practitioners can accept direct briefs, and if you do have an in-house lawyer with a practicing, like we are direct briefing a barrister on a matter at the moment as well. So and they could absolutely come along to a mediation or whatever. Yeah.
Excellent. All right, I've got time for one more question, which is one of my own. So we're seeing a bit of a rise in unrepresented litigants and complainants to businesses that don't have the support of a lawyer. And in particular, I know public organisations are dealing with sovereign citizens at the moment. So do you have any tips for resolving issues early with these types of complainants and litigants that don't necessarily have the support of their own representation?
Yeah, I have to say I was very excited by this idea of the neutral evaluation process. I think that's quite good. It's because really you're trying to in those situations, it's about how can you deal with the knowledge gap disparity around the experience with the process. So yeah, they're absolutely challenging situations, and it really depends on the business appetite in terms of how they want to deal with it, I think, which is organisation specific. But I think making them aware of options like that might be able to be done might mean that if you go to, because I think a mediation might not be attractive in that situation, because you actually want somebody to explain to them certain things, not to say that you're always in the right, but as the business, but you might just need somebody to take a more interventionist approach, but you don't want to go to court. So I think something like that would actually be really useful. So that's probably my takeaway.
Just making sure you've got an evaluative mediator in the room.
Yes,
there's a whole lot of different ways of engaging a mediation, and some mediators will stick to just one kind of approach. I certainly, probably because I'm an ex-litigator, I tend towards the evaluative end. Getting the right person in the room is really important, because that reality testing that they will do when they're in the separate session with them is just absolutely essential. But otherwise, I think the only other two things I'd say is sometimes you need to let them get it out. If you
Absolutely.
don't let them get it out, they're not going to listen.
Yes.
So you've got to let them feel like they've been heard. Otherwise, they're never going to listen to anything you're saying. But if you're not clear, if there's not a clear process from the start as well, just try and focus that conversation on the process. Don't get into the substance of it. Just get the process agreed, because then you can just work your way through. Easier said than done.
Yeah.
Yeah.
Yes, sometimes it can be with those sovereign citizens, but no, that's really useful. And thanks. That's all the time we have for questions. I really appreciate you taking the time to give this presentation to our Islands members. We have in the chat box, someone said thank you and noted that it is a fundamental area of expertise for in-house lawyers. So we really appreciate that. This person asked whether we'd develop a community of practice or other similar group for ADR, and that's absolutely something that the Islands Committee can look at. So look out for that in the newsletter. So once again, thank you so much, Catherine and Gracie. Really appreciate your time, and thanks for everyone for attending.
Thanks for having us.
Sophie.